all they're allowed to do is get into the acts and statements of others that can be said to be in furtherance of that plan. So things that they did that were supposed to be moving that plan forward. If there was such a plan, which we say there wasn't.
If she wants it relitigated, then we may have to relitigate. If she lets it in, then we just litigate with the evidence itself at the end.
How can the conspiracy element and furtherance of a conspiracy element be made out when the police are involved directly in ushering these trucks in and having not only a say, but the say on where they park?
Robert Kraychik here, reporting for Rebel News here in Ottawa, Ontario, at the conclusion of day 29 of the trial of Tamara Lich and Chris Barber. Both are being charged with crimes associated with their roles as organizers of the 2022 Freedom Convoy. You all remember it. It was a large, peaceful demonstration here in downtown Ottawa in opposition to what I regularly describe as the COVID-19 enterprise. Edicts, mandates, lockdowns. The day's proceedings were primarily dedicated to a continuation of what we saw yesterday, which is this ongoing dispute between the prosecution, both defense teams, regarding a Carter application, which I will explain to you all, dear folks in the audience, in a moment. We were fortunate enough to speak with Diane Magus, attorney for Chris Barber, and also Eric Granger, co-counsel for Tamara Lich. Before we get there, though, just want to remind you folks that we need your financial support to continue producing these in-the-field reports for you all to enjoy. So please visit tamaratrial.com, contribute to our operational costs, and stay up to date with our ongoing coverage. For a Carter application to be approved, to be justified, to be accepted by a judge, the application must fulfill certain criteria. The most important criteria, the first one, is that a conspiracy to commit a crime, an unlawful common purpose, must be demonstrated beyond a reasonable doubt to the judge. There's got to be some sort of evidence of that. Now, number two, there needs to be evidence of furtherance of that criminal conspiracy. There must be evidence that steps were taken towards advancing that intended crime. The latter portion of today's proceedings were primarily dedicated to Diane Magus's argumentation, in which she was sharing many statements made by Chris Barber, both publicly and privately. So formerly in the form of, let's say, TikTok videos that he would publish for public consumption, statements that he had made that were captured publicly on news media videos, and also texts that he had sent directly to Tamara Lich and others. And the common theme is something we've all heard before across the course of this trial. Chris Barber is repeatedly emphasizing the need for all demonstrators, protesters, taking part in and supporting the Freedom Convoy to remain peaceful. That word came up over and over and over again. He's also emphasizing the need to be mindful of impacts on Ottawa residents, to be congenial with them. They didn't ask for this. That's a direct quote from Chris Barber in reference to Ottawans that were being impacted in one way or another negatively by the presence of this demonstration. He regularly calls for all protesters and demonstrators to comply with, to coordinate with, and to be respectful towards police officers. So why was Magus sharing all this information? Because she's using it to challenge the assertion coming from the prosecution that the conduct of Chris Barber constituted evidence of a criminal conspiracy, plan to commit something unlawful, a crime.
There's three things they've got to prove. The first is that there's some sort of conspiracy or unlawful objectives, something unlawful, some sort of crime, that there has to be an agreement by two or more people to commit a crime. And there's got to be evidence that can prove that beyond a reasonable doubt. The second thing is they've got to link someone to that plan, link somebody to that plan to commit a crime. So they've got to have some evidence, in our case, linking Tamara Lich to a plan to commit a crime. And then if they can somehow prove those two things, if there's somehow evidence of those two things, both that there was a plan to commit a crime, an agreement to commit a crime, and that there's evidence suggesting that Ms. Lich could be part of that plan. We say there's no evidence of either of those things, but if somehow the judge decides otherwise, then all they're allowed to do is get into the acts and statements of others that can be said to be in furtherance of that plan. So things that they did that were supposed to be moving that plan forward. If there was such a plan, which we say there wasn't.
What does the next series of the process look like? Do you sort of relitigate this entire thing? Does the prosecution then make its case in support of the Carter application, and you guys then respond or rebut that?
It gets a bit complicated, and some of the steps after are not yet revealed to the Crown, so can't speak too much, but there may be some relitigation of the Carter issues depending on the ruling. So if she wants it relitigated, then we may have to relitigate. If she lets it in, then we just litigate with the evidence itself at the end.
They pointed out that it would be difficult. It's going to be difficult for the Crown to make out their Carter application, and this should form some of the basis for tossing the Carter application before we get started, because all along the way, at least initially, the police were sort of, there was this theme of police ushering trucks in, telling them where to park, where to go, and then not just telling them, but also, on the other hand, compliance coming from Chris Barber in parking in the places that he was directed to park. So the question is, with respect to the Carter application that Magus and Granger are asking, is how can the conspiracy element and furtherance of a conspiracy element be made out when the police are involved directly in ushering these trucks in and having not only a say, but the say on where they park on the road.
As far as the actual time frame, if you have some sort of expectation, do you expect the judge to rule on this somewhere by, let's say, Thursday or Friday, by the end of this week, or did she already state that she'll have that no earlier than next week?
Well, unless I misunderstood her, she indicated, as I understood it yesterday morning, that she's certainly going to need some time in order to rule on this. Obviously, she's already heard 2 days of arguments on this. We're going to be into a third day of argument, and we haven't even heard from the Crown yet. So obviously, quite a bit of, obviously, we had 27 days of evidence, not necessarily all evidence, but 27 days of the Crown's case, plus at least into a third day at least of argument on this. She's got quite a bit to consider, and has already told us that that's going to take some time. So certainly not expected this week, and no date at this point set for when we can expect a decision.
Are there particular things that you remember from evidence that was presented from the Crown that stands out in your mind?
In their position before the court is that the statement from Tamara are not in furtherance or of any unlawful common purpose, so they wouldn't meet the Carter test in any event. So it's not that we're afraid of anything she said, it's that it doesn't meet the test, so it should not be allowed.
Dear Rebel News audience, we depend on your financial support to continue delivering this in-the-field journalism, so please help us out. Visit tamaratrial.com, contribute if you can, and stay up to date with our ongoing coverage.